Hi, Michael. Can you hear me?
I sure can.
Okay, great. Okay, so I'm starting the session. So, hi everyone and welcome. Um, Good afternoon. And thank you so much for taking some time to join us today. I'm Swatilina Barik, and I'm going to host this session today. Before we begin, I just wanted to wrap up a few lines and just saying some stuffs in terms of 2025 that what we have seen. So we know that US immigration is being evolving rapidly, and for high-skilled professionals and founders and global talent, the stakes are very real. Uh, Navigating H-1B, exploring O-1, or even preparing for EB-1A. Um, Now, understanding the updates on immigration is not anymore optional, but it's essential. And definitely, we are going to gain a lot of clarity on what's changing, what it means for your immigration journey, and how you can respond strategically, not just reactively. We are honored to have Attorney Michael Hendricks with us today, an immigration attorney who has guided many professionals and employers through complex immigration procedures and evolving policies environment. Please feel free to drop your questions as well in the chat box, and we can take up later once Michael explains us about the theme of the session. Thank you so much, Michael, for joining us today. Um, the floor is yours.
Thank you, Swati. Can you help me by allowing me the opportunity to share my screen so that I can provide the presentation?
Yes,
It says that its host has disabled it. So can you give me the option to share? And while she's doing that, yes, my name is Michael Hendricks. I've been an immigration attorney for over 12 years, been working in immigration law for almost 15 years, have helped thousands of people and their families be able to obtain benefits across the immigration spectrum, employment based, family based, victim based, every different type. Have a very high win percentage, over 98% in most. But I did read a good article the other day that talked about the win percentage and generally talked about whether those are very important. And I agree with the article. The article's basis was that they're not. And that's because it really depends on what kind of cases you take. And so a lot of times certain practices will really, as long as the client wants to, will move forward with cases that have a lower likelihood of approval, because sometimes it's like my mentor taught me, sometimes 1 in a million is better than not doing anything. I've not practiced that way generally. I look and see if there's at least I provide clients information about the viability of their case and let them know what the likelihood of approval is. And then, of course, it's up to them, and I take the case as they come on if they want to move forward. But I provide sufficient information to where people are like, okay, you're right, you're spending the money that I'm going to spend if there's not a high likelihood of approval. And nowadays, that's even become more important. So that's not the case of many of you people that are on here watching today. But I do want to really cover some specifics because some of the big things that we've seen recently have been, increased RFEs for EB1As and O1As, and I wanted to touch on that and see the underlying reasons behind, because no one's really given. I've read a lot of articles on this, and USCIS doesn't actually publish RFE rates specifically, but anecdotally, we know that there's been an increase, and not a whole lot of people have good reasons as to why. And I think I've determined the reason based on the questions in RFEs. We'll talk about the H-1B, the new fee, who it applies to, who it doesn't apply to. We'll also talk a little bit about EB-5s and other investor type visas. That may be something that you want to look into. And we'll talk about bridging the gap, not just in H-1B, but various different types when you're waiting on a specific process and you need to change your current status in order to kind of give yourself more time. So we'll be talking about all of those things today. And as Swati said, please put your questions in the chat. That way we can address them. I'll go through the presentation, and then you can put your questions either in the chat or write them down and then ask them as we move forward. So let me see if I can share my screen. Great, I can. All right, so let's move forward. All right, so hopefully everybody can see my screen. Swati, can you see it?
Yes, Michael.
Okay, perfect. I'm going to do this on presentation mode. So it doesn't have all the other stuff. Okay, so let's talk about key immigration trends and strategic alternatives, specifically targeting high-skilled professionals and sponsoring employers. So this is for various people. This presentation, not just for the person seeking to apply, but also employers that are seeking to bring people in. So obviously, we've seen over the past year, primarily since January, the new administration came in. There have been significant changes. And I'm going to say I've been in immigration. Actually, the first time I started working in immigration was as a salesperson in 2001 before the towers fell. That was the first time I worked in immigration. I was working with an immigration lawyer out of Alabama and helping him access, in that case, mostly Spanish-speaking clientele, since I grew up in Mexico as a missionary kid, didn't move to the U.S. till I was 17. So I was an immigrant in a foreign country until I was 17. And I've never seen this level of change in immigration policy and procedure in my time working in immigration. And you're talking about 24 years in and out. I've never seen it. The changes that have come have been very unique in the way that they've been done. It's not been law changes, right? There's been no change to the law. The INA is still the INA. There's been no effect. There's been no congressional change to the law. This has all been done through executive fiat. The thing is that the executive under our specific type of government, and most of you come from countries with a very similar type of government, whether they be full Congress or you have houses, the House of Lords, House of Commons, prime ministers, presidents, it doesn't really matter. A lot of it comes down to the same thing. But in ours specifically, you have to have Congress, House or Senate, create a bill. Bill is pushed through, goes through several committees, gets passed through, then gets sent to the other house, whether it's the lower or upper, depending on who started it. There could be amendments done. Subsequently, there has to be a vote on those. They go through some committees. There's a vote on those. If there's amendments done, it has to go back to the other house, whether upper or lower. And then once it's passed through both houses with the requirements, then it goes to the president for signature. That has not happened. We have been hoping that something like that would happen in a positive way, and I still have hopes that that could happen over the next couple of years, but it hasn't happened yet. So let's look at the changes that have happened and some strategic alternatives. So let's start with the H-1B fee structure. So as we all know, it's been highly publicized. There is now attached a $100,000 fee to the H-1B. Now, I want to talk about who this applies to because it doesn't apply to everyone. Let me see. It's not letting me. There we go. Okay. So the H-1B, important because when we first heard about the H-1B, there was no real clear information as to who it was going to apply to. It just looked like it was across the board. And the only people that we knew that were exempt originally were people who were looking to renew their H-1B. After this, once we got the full policy, once it went through some legal hurdles, and finally a judge recently agreed that the H-1B fee could be assessed. So the U.S. Chamber of Commerce lost its lawsuit, and they may try to appeal. There's all kinds of things that could happen, but for now it is in place. And it's very important because it mostly only applies to H-1B cap subject petitioners. So employers looking to find people who are H-1B cap subject, but specifically, it does not apply to the extensions and renewals, as we knew, or the transfers, which are very important because there's a lot of people already here. They have their H-1B. They're looking to renew, especially some of the group that's here with the EB-1As and O-1As. A lot of you guys already have H-1Bs in place. That's how you're currently working. Some of you are on OPT. The good thing is that it also, OPT or CPT, it also doesn't change that. So if a person is in the U.S. on a visa, similar to F1, and there are some others, and we can talk about those, but F1 visa, like a student visa, and you're converting to an H1B, the fee does not apply to you as well. So really who we see it applies to, we'll just boil it down. It really applies to people who are outside the US that are looking to enter the US via H1B. That's who it does. And so really it's putting a fundamental reorientation of talent strategy to domestic acquisitions. This has been something that the government has done for a long time. We all know that there's a certain subset of the H-1Bs that are set aside for people who graduated their masters in the US. So it's very important to realize this isn't a change in the way they think. They have always done that, because what they're doing is they're saying, we trained you, now we want to keep your talent. Okay. So that's really fundamentally what it comes down to. And they trust the training. When I say they, I'm talking about the US government generally. They trust the training that happened in the US. They know that you've probably gotten some of the best training in the world outside of maybe some places in the UK. You're getting the best training in the world, which means that they want to keep your talent here. Why? Because you are now going to contribute to the US economy. There is a double standard here in that H-1Bs only last 6 years. Now, we know that the extension can happen. If you get an EB in the process, you can get an extension on your H-1B while your EB, kind of bridging the gap with the H-1B while your EB is processing. So we all know about that. But generally, H-1B is a 6-year visa. Why they would want you to leave after 6 years and take your talent elsewhere, that I can't explain to you, but they've really have been oriented around keeping trained talent in the US. So the impact on the market really is going to be for small and medium-sized businesses. It's going to be prohibitive. What you need to remember is that when you enter the portal for a cap subject H-1B and you're outside the US, you're looking to come in under an H-1B, the $100,000 fee is not payable until they actually selected you. Okay. Now, there has been a change in the way the H-1B is being selected. That's the other big issue, right? Which is now they're more focused on the higher wage earners. Okay. So it's very important to remember that the lower entry level H-1Bs are really, it's not that they're going away. It's just going to be a lot less likely that you're selected. So there's a weighted value placed. So really the H-1Bs that are going to be selected more than not are going to be the ones at level 3 and level 4. Very important, because if you're somebody that just finished your bachelor's, remember, H-1B is not weighted based on your education alone. So it's not like, oh, I have a master's now, so I jump up to another level, or I have a doctorate, so I jump up to another level automatically. No, usually it is a combination of education and experience. That's what ends up pushing you up the levels. So if you've been looking at an H-1B and you're abroad and you're like, look, I think I found an employer that's willing to do it. I just got my bachelor's in, computer science or IT or whatever else it is. And I'm a specialist in AI, right? Because AI is the big fad right now. I'm a specialist in AI. You coming out with a bachelor's degree or even a master's without having real world experience, the likelihood of you getting an H-1B is very, very low. Now, because of the cost, there's another factor, which means that there are going to be less applicants. That's the prediction. The prediction is that because of the fee that's associated with it now, there'll be less applicants in the pool. So every year they give out the 65,000. And they increase that and decrease it sometimes, but around there, 65, 75. So what ends up happening is there are 650,000 people that go into the portal, right? So you have a 1 in 10 chance. Before, you had a 1 in 10 chance. What's going to happen with the weighted model now is that there are going to be a lot less people that apply, because there's a lot less businesses that are willing to spend the $100,000 if their person is selected. So there's going to be a lot less applicants, which means that the weighted value will put the higher quantity in the 3s and 4s, but then there'll probably be more availability per capita, so to speak, per applicant for the lower level as well. So just keep that in mind. But the strategic market position that you can take is really assessing whether there are other visas that you can look to apply for outside of the H-1B. So market segmentation, it favors companies with capital depth, right? Whereas you could do it O-1A, that doesn't require the employer, right? So then you're not worried about the capital depth of whoever it is that was looking to bring you in. There are alternatives also of crucial differentiators, talent acquisitions, corporate visa economics, and of course, geographic and operational flexibility. One of the things you could do is look to come and finish a master's degree on an F1 so that you're physically present when you're ready to move forward with the H-1B. And now you're no longer subject to the $100,000 fee, or your employer rather is no longer subject to that. So the strategic conclusions in this part is prioritizing a domestic talent acquisition. We understand that. If you're domestic, there's no fee. The $100,000 fee doesn't apply. It also will push people to the L1 and O1. So getting into a company at an international level, working for them, and after you've put your time in there, being able to transfer in under an L1 management visa. And there's L1A and L1B. L1B is a little bit lower criteria, can bring in people who are a little bit different in what their job descriptions are. But they do require also certain specific qualities and criteria in order to be able to meet the standards. And then for employers, it's going to require sophisticated financial modeling, right? So they need to make sure they're building out a pretty nuanced base for how to pay these fees and who is going to be the people that they're specifically looking for certain talent in order for them to be able to acquire that talent without having to pay the $100,000. And for the rare person that they pay the $100,000 for, you're talking about the Microsofts and Googles of the world. And there are other large companies too that are going to be willing to pay the $100,000. But a lot of times when you're looking at the specific person you're bringing in H-1B, they're going to have to be a pretty high level person, first of all, to be selected. And secondly, for the company to be willing to pay $100,000 as a visa cost. So let's move on so we've talked about the wage-based and the lottery reform. And so declining odds for entry level, although we think they might increase because of the lower amount. But there are other alternatives as well. The TN visa, if you're from Canada or Mexico. If there's any companies listening, that may be a good alternative for you, is TN visa. The E3, if you're Australian, of course, F1 OPT and STEM OPT, the CPTs, and then O1A candidates. Of course, we're going to talk about why there's been more RFEs in the O1 and EB1. And we're going to talk a little bit about whether or not that should be something you apply for immediately, or if you need to dig a little deeper. So there has been a shift. We're moving on to the EB1As and in some cases the O1As and the other employment base. So there's been a shift, not a legal shift. Like the law has not changed. And this is a shift, once again, just very similar to how the H-1Bs previously still gave a special opportunity for those that had graduated masters in the U.S. getting a special group subset inside the H-1B. So too, it was exacerbated. So it was increased with this new policy change. The same thing is true here. So there is obviously a quantity portion of the EB1A and the O1A. Okay, quantity meaning that you have been published, that you have X amount of peer reviews, that you could have a book, you could have high pay in your industry. There's all of these quantity, which means that it's just about how much you get. Now they're really shifting to a more quantifiable impact in the form of depth. So when you have a bunch of pieces of a puzzle, you kind of put them together and it makes it really wide. Now they're going into a deep level. So now it's a 3D version. So understanding the adjudicative shift is interpretation, not new regulation. Very important. No new regulation has been promulgated. These are all the ways, these are what are called SOPs, standard operating procedures. Basically, they have shifted the standard operating procedure. And so there's a stricter burden of proof. This is why RFEs have come out. So they're enforcing an initial burden of proof and it rests entirely on the petition. You have to remember that. The petitioner is the one that has to prove that they qualify for this. And they've received, when I say they, I'm talking about USCIS, have received internal guidance to scrutinize every criterion independently, ensuring evidence demonstrates sustained national or international acclaim rather than an isolated achievement or regional recognition. Okay. More focused on quantifiable metrics. primary triggers from what I can tell and what we've seen anecdotally is failure to connect evidence to required criteria. Not have you been published, but where were you published? Who's used your sources? How many times have you been cited? If you have a patent, who's using your patent? How many people are using your patent? Not just do I have one now. So before it went from a quantity to quantifiably deep, right? So it's changing the way that they're looking at it. So they're doing a much deeper dive into what is happened with, like, if you've published something, how many times it's been cited, audience and reaching for media coverage. So it's become much more subjective assessment about the insufficiency of the use of what you've done. So it's one thing to say, I got published. It's another thing to say, my paper not only was published, but it was published in a high-level publication, and it's been used by other publications to cite some type of metric or some type of truth, right? Or the theory has been cited as a provable theory that's starting to get proven out over time, and then it becomes a standard practice. So also media credibility standards, increasingly focus on high credibility national and international news sources. Regional publications, industry blogs, or promotional materials carry very little weight. So what people have done up until now is they prepare everything, they get it ready, and then they submit, and they're paying attention more to the amount of stuff that they're submitting rather than the depth of stuff that they're submitting. So 1,000-page EB1A, for instance, application, it's really good. It's like overwhelming documentation, but the government's like, no, that no longer qualifies you. Just showing that you've done these things no longer qualifies you. We need to see what actual impact you've had in the world around you. So that's one of the reasons we're seeing RFEs. The other is there's always a backlog. Okay, so there's always a backlog. And when you pay for premium processing, you're saying, they're telling you, we guarantee you in 15 days, we're going to give you an answer. They can't give you an answer in 15 days. That's the problem. There are too many people applying and not enough officers. So what they do is they look through something, they find reasons to RFE, and they send out an RFE, and it buys them a couple of months, because by the time you respond, they get to review it. Then it's going to be a couple of months before they have to get to yours and make sure that they re-review it for a more substantial review and a more substantial answer. So making sure that USCIS, they don't publish their RFEs, and they don't do it on purpose, right? So I have people ask me all the time, what's the wait time for X? Or how long is it going to take my appeal to go through? The government doesn't publish the majority of those. They publish the basic form-based responses. So, and then even they're starting to do them as a unit rather than separated by different regional centers. So you have to remember that since they don't publish it, a lot of this is anecdotal, like from AILA and proprietary databases from law firms and other places. I think one of the big ones is Lawfully. Lawfully is an app where you can track your applications after they've been submitted. And so what they've done is create an algorithm, and because they have so many people that use their app to track their applications, they've been able to determine what RFE percentages based on their users and the people that feed them information. So we have seen an increase. It is a substantial increase. And it seems like the increase is primarily not because you don't qualify, but primarily for two reasons. One, because the people that don't qualify, because they have no depth to their application. They have a lot of width. And we used to talk about this. So I'm a pastor as well. And so one of the things we talk about is somebody has faith, right? Is your faith as wide? It could be a mile wide and an inch deep, which means it's very superficial. You can see it everywhere. But if hardship comes, then there's no real depth to it. And so it fades away. So the idea is that we have your evidence, like your faith, be the width necessary in order to cover the criteria, but really focus more on the depth of it and make sure that it's being used around your unit, like for instance, in your different type of work, whether it's in AI or whatever it may be in, so that there's a proof that you're actually showing that you have a major impact, because we're talking about extraordinary ability, right? This is not an easy burden to bear. Extraordinary means that you are extraordinary. There's the ordinary world, and they're weighing you against other people in your same area. So you have a bunch of people that work in AI. You have to show that you are extraordinary. You're above. significantly above those around you. So they become much more strict. And it looks like those are the two main reasons, that and case backlog management. So strategic conclusions, front load case development. It may take you longer to build your case. It doesn't matter, because having a case that is built correctly and is done in a depth with the depth necessary to be approved, those are going to reduce your likelihood of an RFE. And then making sure that you keep in line with keeping up with the metrics, not you necessarily, but the people you're working with, keep up with the metrics of what's being filed and when, because the government does publish that, and there are ebbs and flows to applications throughout the year. So maybe applying when things are lower is less likelihood of an RFE, right? Pivot to a measurable impact, depth versus width, right? And then proactive RFE budgeting. This is more for law firms and businesses, knowing that there could be an increased cost for RFE responses. So let's talk about the EB-5 program and the Gold Card investment pathway. So we've now heard about the Gold Card. It is actually officially available. They're talking about also doing a Platinum Card, which may make things even more interesting. But EB-5 is an investment visa that is used. You can do direct investment, or you can do through a regional center. But it's investment requirements of $800,000 in a targeted employment area, or $1,050,000 in a standard. Job creation mandated, must create or preserve 10 full-time jobs for U.S. workers. Those could be U.S. citizens or lawful permanent residents. Those are not H-1B employees. Those are not F-1 OPTs. Those people do not qualify when you're talking about a measurable impact for job creation. Legal stability, change required congressional legislation provide long-term predictability. So they're looking at creating a long-term predictability for the EB-5s. So there's less, because there's EB-5 throughout the years has been rampant with fraud. It's just been one of the things that they've had. H-1B was the same way, which is why they've done various changes to H-1B over the years, because there was so much fraud happening at the congressional level and the Senate level, to where they would give out benefits to their friends. So anybody that thinks that the government doesn't have corruption in the U.S., you're dead wrong. There's just as much corruption here as any other country. They just wrap themselves in the American flag and say that it's patriotic, and it's not, right? So just make sure. And then the primary risk is obviously financial, investment performance, and job creation compliance. For investors with high risk aversion and multi-generational planning, EB-5 remains the most stable and predictable route to permanent residency. Now, remember that this is direct investment, where you have to do these things. If you do it through a regional center, they take care of that. But still, verifying that the regional center that you're working with, or the investment that you're making, is legitimate. You are putting money in. Most of us on this call are people who, if we're going to put that kind of money in, we're looking for ROI on our investment. We're not just throwing money in. And remember, you get a temporary conditional residency. And then you have to come back after 2 years and prove that that investment is still what you said it was, in order for you to be able to take those conditions off and be able to move forward to a full permanent residency, which then allows you to move forward to a citizenship if you so desire after 5 years. In comparison, the Gold Card, this is an executive initiative. This is an attempt for the current administration to reduce our current deficit and to reduce our current debt load. That's the whole thing. That's it. They're selling green cards in order to reduce our debt. Okay. So the appeal of it is an expedited processing, potentially streamlined requirements for high and ultra high wealth net worth individuals. The legal basis, it's grounded in executive fiat, vulnerable to administrative changes. Although if it begins to work, I don't foresee that they'll make changes to it unless they increase the cost. And the reason is because if we do start seeing enough people doing this, and a reduction in the deficit and a reduction in our debt. So deficit is what we make versus what we spend every year. Most of you probably know this, but just anybody who doesn't, the debt is what we've accumulated over time. And most of you probably know we're at like 32 trillion. A big portion of that is owed to China, actually. And so other bonds and other folks. So the government is trying to figure out a way to not cut all Medicaid and Medicare, right? And still make the deficit disappear, and then have a profit at the end of the year, a net profit, which then allows us to start paying down our debt rather than just sustaining or increasing. So that's the primary risk. Political regulatory program can be modified or eliminated, and clarity deficit, lack of established precedent, and long-term legal protection. So we'll see how that moves forward, but at least we have a good understanding of that. If I'm not mistaken, that's a $1 million. It could be more than that. I don't know that I looked at the final policy, but I think it's a 1 million. And then the platinum, when they're talking about being the 5 million. So this is for wealth advisors, making sure, I don't know if there's any wealth advisors, probably not, but just make sure that you're looking up to see what it is that you're getting into, and make sure that it's something that makes sense for the person, that is for your client, that is you're managing their funds. You don't want to end up having a fiduciary issue where you put into a poorly maintained or poorly created program that then ends up costing your client $1 million without any true benefit on the end. So let's talk about some strategic bridge visas, and we're going to talk about dual intent versus single intent. Some of you may already know some of this stuff, but very important and very much worth mentioning. Most temporary work visas are not dual intent visas. In fact, the standard for immigration is that anything that is temporary is you cannot have permanent intentions. What's the difference? Temporary is anything that has a final date. In other words, I'm coming to work on an O1 for X amount of years, O1A, right? That one happens to be dual intent. But let's say I'm coming on an a B2 visitor visa. I have 6 months, or if you're ESTA, you have 90 days. That can never be used. So specifically, ESTA can never be used as a dual intent. You cannot get a green card, even if you get married or whatever else. You cannot get a green card after entering with that visa. That is one of the specific restrictions. B2s, you cannot have dual intent either. Although if you're here, we have a lot of clients that are in the U.S. for 20 years after entering a B2. They have a kid, the kid's a U.S. citizen. When the kid turns 21, they can fix their green card, even though they overstayed their permit of 6 months by 21, 22 years. But even though it's not dual intent. Now, if they can prove that you intended to immigrate to the United States when you entered on that visitor visa, they're going to put on a fraud restriction. There's a waiver for fraud restriction, but it cannot be given by children, and it cannot be given by employers. It can only be given by parents or spouses that are lawful permanent residents or U.S. citizens, as compared to the dual intent, okay? So also just remember, F1 falls into the single intent visas, just so you know. So if you're going to move from F1 to something, you need to move to something that can have more of a dual intent. H-1B is the quintessential dual intent visa. You can enter on an H-1B temporarily to come work and have an intention upon entry to get your green card at some point. You're allowed to do that, as compared to F1, where you're not allowed to do that. If they believe that if they can prove, so to speak, that you entered with the intent of migrating permanently to the United States, immigrating permanently, then you will be hit with the fraud charge. And so you want to be very careful. So H-1B, L-1, E-3, E-2 really can fall inside of this as well, although it's kind of up in the air. There's no standard for it, but E-2s usually you can use for that as well. O-1As are ones that can be used for dual intent. So it's a good bridge visa if you're on, let's say you entered with a visitor visa or an F1, better speaking, and you're not going the H-1B route, you're going to go the O-1 route. O-1s are also ones where you can have the intention of immigrating permanently to the United States. So very, very, very careful with how you are moving around your visas if you're wanting to stay and not have to leave and come back. So here are some strategic uses. You can use a B1 for people who are B2. Sorry for people. B1, B2 is the same visa. One has more of a work intent. It's like coming for a conference and stuff like that. Doing a conference, speaking at a conference, as long as you're not getting paid by a U.S. employer or a U.S. company, or they're paying your foreign national company. So I have a company in Mexico. They asked me to come speak at a conference. They paid my company for me to come speak, right? So that's okay as a B1. B2 is strictly tourist. And so really that's the one. So if a person's F1 is about to expire, their OPT is about to expire, and they don't have the CPT or no STEM extensions, you could flip over to a B2, stay here while you're applying for O1 or EB1A. preferably to prepare for the completion of those packets. Although an O1A, since it's a temporary visa, temporary work visa, you can also use the B2. You can actually apply for your O1A or O1 strictly. EB1A is a little bit different because that's more of a permanent application. So obviously the risk is intent. F1 OPT students applying for other things, accumulating experience and so on. So you just got to be careful because now the new standards, the way they're looking at it, having a lower level of impact in your industry is not going to be enough to qualify for an O1A or an EB1A. So if you are very low level, like you've only been doing what you're doing on OPT for and maybe CPT for 2 years, 2.5 years, and you've made an impact, something you did is extraordinary, then going O1A rather than EB1A would probably be your choice. Get the O1A done, start applying for that, and then start thinking about moving to your EB1A as you move forward down your pathway. The consular process doctrine, crucial pitfall is the greatest risk occurs with obviously we talked about the single intent visas. The problem is the consular officer has a very high bar for proving non-immigrant intent. The result, the applicant can be denied the visa stamping or denied reentry. So here's a big deal. There are people that have visitor visas that come and go on visitor visas or come and go on like an F1 visa. If you are an F1, for instance, and you apply for an EB1A and you travel abroad, they can deny your return to the US because you have an ongoing permanent visa application. So be very, very, very careful when you're traveling abroad and you're applying for certain things and you're trying to enter on a visa that could be a single intent visa alone. So don't just take things for granted. And I know a lot of people don't do that nowadays because of the way everything has been enforced recently. But just make sure that you're paying attention. And then the strategic risks and recommendations. Avoid B2 when you're filing an I-140 or an F1 if you've already filed an F-140. Prioritize getting on a dual intent visa. Obviously, the safe bridge is the O1A, fantastic bridge between technical non-immigrant and being able to move towards an immigrant visa. Non-immigrant being that you're not looking to immigrate permanently. Immigrant visa meaning you're wanting to immigrate permanently. So I didn't know if I actually defined those terms, but that's what they mean. The only true safe strategy while pursuing permanent residency is to maintain a dual intent non-immigrant status like an H-1B, O-1A, those kinds of things. So the key takeaways is cost optimization for H-1B strategies. You've got to make sure that they're looking into and verifying if you fall under the category. If you do not, then you're probably pretty safe. If you do fall into the category, looking for other pathways where it won't cost the 100,000, L1, O1s, wage level strategic positioning, making sure conducting a salary planning, enhanced evidentiary standards, remembering don't just worry about the amount of paperwork you're going to give them. It has to show depth and it has to show a quantifiable national or international impact. Very, very, very important in order to avoid RFEs or to be able to overcome RFEs. And then risk calibration, making sure that you understand what you're investing in if you're doing an investment visa, E2, EB5, so on and so forth. And so let's see, I think that's the last one. And so I'll open it up to any questions that you may have. This is being recorded as far as I know. But before we move on to that, I want everyone on this call to know I am a lawyer. I am not your lawyer. Therefore, the information that I'm giving is for general purposes. This is not legal advice specific to your situation. Do not take what I'm saying and try to go to your attorney and say, we should change everything that we're doing. You need to work with the attorney that you have, if you have one. If you do not, make sure you take the information and consult with an attorney that knows what they're doing. Don't ask the attorney, how many EB1As have you won in the last 10 years? That doesn't matter. What matters is whether or not they understand how immigration processes immigration cases. It doesn't matter if you're filing an EB1A or if you're filing an adjustment of status or if you're filing for an F1. Immigration is immigration. The government has standards, and understanding what those standards are and how to meet those standards, that's your best friend, not whether or not they've won 100 EB1As in the last year. That is of no importance. And I know a lot of you are like, that sounds counterintuitive. It is, but it is the way it works with immigration. As long as you understand it. The reason I have a 98+% rate and I hardly ever get RFEs on anything that I file is not because I'm a magic worker, and it's not because I've done 100 EB1As or 500 EB5s or whatever. It's because I understand who immigration is, what they want to see. I do my due diligence to make sure that I'm understanding how they're looking at things today, and I think like an officer. Thinking like an officer then puts me into the position to say, would I approve this? And by the way, I'm way more conservative than most of the officers that work for USCIS. So if I wouldn't approve it, I'm just going to assume they wouldn't approve it, which means that we then need to do more in order to develop the standard by which we can get an approval. So thank you.
Thank you so much, Michael. It was incredibly insightful, but I don't see any questions at the chat box. But I'm pretty sure that in our audience, there are many people who are in H1B, F1, and getting RFE. So I have a question, Michael.
Please.
I've been dealing like a lot of EB1A and O1, EB2 and IW, H1B L1s. So I have seen it's being like this year was a lot about RFE and NOIDs. So there is like anxiety when we get or when the applicant receives a RFE or a NOID. I just wanted to understand how they should take the RFE or a NOID, how should be the mindset shift and how it should have been like taken up, and because it's very important also how we argue, that's the most important factor. So the fear that it is having in the mind, so how should one think about it?
Okay, so we'll talk about NOIDs first because I think that's easier. A NOID is a death sentence. They haven't automatically denied you, but if you get a NOID, it's not impossible, but it is almost impossible to overcome a notice of intent to deny. Why is that? Because they've already reviewed sufficient information in your application and they have the full intention of denying your application. Why they send out a NOID and not just send out a denial, I still don't understand that yet, because I've had NOIDs that have happened in the past where we provided them mountains of evidence. A NOID that I had on citizenship, for instance, is a great example. We provided them a mountain of evidence of the relationship that existed exists between this husband and wife for an adjustment of status. Sorry, not MATS, adjustment of status. Yet they still denied it. Now, she ended up applying again and she got approved. Why? Because we were able to fix the problems that were in the application. We didn't do the original application. It was brought to me as a NOID. Okay. So there were issues that had been put in the application initially. So the other part is RFEs. Having the correct information. And the real question is, what is the correct information? Right? Because the government, they give instructions. They say, in order to qualify for an O1A or an EB1A or an NIW, you have these criteria and you have to meet X amount, whether it's 3, 4, 6, whatever it may be, right? There are 10 criteria. You got to meet 3 of them for an O1A, right? Okay, or 2 of them. So have you done that? And what we have focused on in the past is basically just overwhelming the government with, no, I've not met 2 of them. I've met 6. Right? I've done all of this stuff. You should know that I'm extraordinary. Or I have like national interest waivers. You got to make sure that whatever you're doing is actually within the national interest, right? Because there's a lot of people like, I want to do an NIW. And it's like, okay, well, what are you working in? Oh, well, I work in, engineering. Okay, but is your form of engineering in the national interest, right? Is this an area that is required right now that is in the national interest that says, yes, we need to bring people like that because we have a national interest for this type of person, okay? So that's one. Number 2, we are going to have to transition from a mountain of evidence to depth of evidence. So the anxiety that exists, I totally understand it. But I'm sure that everybody in this call, everybody in this webinar has previously taken a test, right? Some very high level test where you're going to school and it's like, it's time to do. I remember when I was in law school, You never had any grades throughout the year. It was just your final exams. They were almost all 3-hour exams. There were some that were 8-hour exams where you had 8 hours to take them. You had to sit down and you had to do it all in one sitting, right? 8 hours. Anxiety. Why? Because what if I don't remember everything in my three? I just studied for 4 months, all of this stuff, and now I'm having to take an exam on it or write an opinion, right? How do I make sure that I'm ready? The same way you do for a test. You study and prepare. What does that mean? I've talked to tons of EB1A people, and it's like, oh, I'm working on those letters, or I'm doing this, or rewrite that letter for me, whatever. You are the interested party. Getting help from people who are experts, that's great. Knowing what substance to put into a letter, but having the depth in that letter, having the depth in making sure that other people are using your material as a citation, finding people who could use whatever it is you've built or the patent that you have created, how the other people can use it, and pushing that forward. So that's really, so the key to reducing anxiety is preparation. The fact is that the government has no intent to deny everybody. We need people. The U.S. needs people. We have deficits in many areas. We don't have enough people studying in IT and computer science. We don't have enough people studying in engineering. We don't have enough people studying in medicine. What makes it to where you can come and do it? Well, I'm going to show you that not only do I qualify, but I merit a favorable discretion in this application. And why? Because I've proven to you that I've had substantial impact, whether national or international. So it's really focusing on the depth of the application, and that reduces the anxiety, which then helps you be able to move forward. It's not about overwhelming with pieces of paper. It's about overwhelming with the impact that you've had. So for some people on this call that have already applied, it's not too late. You can augment your application with additional information, finding people who will cite you, finding the citations, getting it pushed out, doing more of that, and then finding people who may need to use the patent that you've created. And even if it's like, I don't necessarily need you to pay me to use what I've created, right, based on this patent. But I need you to use it and give me positive feedback. Well, now you have people that are using whatever it is that you created, whether it's an algorithm, whether it's a patent for an actual object, whatever it may be. You find people who can use it, and now you show that there are people being impacted with what you've done, and maybe getting into higher level publications when possible.
Thank you, Michael. I do have some other questions. So there is one question by Martin, and he's asking that what would be your assessment on the TN visa going away if there is no NAFTA agreement comes in 2026?
Well, first of all, the NAFTA agreement is gone anyway. It's now called
Yeah.
USMCA, which is the US-Mexico-Canada agreement. I do not foresee USMCA going away. I don't think so. So the USMCA was reestablished, moved from NAFTA to USMCA under President Trump in the first administration.
Yeah.
So I don't see him taking away the thing that he fought so hard to get. And not only that, our number one partner for trade is Mexico. So it's like you're not going to take away, because half of our cars that are in the U.S. are built in Mexico, the parts and the cars themselves. So I don't foresee the USMCA going anywhere. It's a strong visa. It's a very necessary visa, and it really competes with the EU in terms of having a tax-free zone. It's not tax-free. Now, Canada has bristles at its feathers, right? After President Trump did his stuff, right? Now Canada's like, we won't be bullied, right? And it's like, okay, but you will, because you're Canada and this is the US, right? And then Mexico with the cartels and drug trafficking. That's the only things that I could see as possibly. And I grew up in Mexico. Like, I grew up in the area where the drug traffickers put their children because that was the safest part of Mexico. We didn't know that. It just happened to be where we lived. So I knew a lot of them, the kids of the drug traffic, the people that were in charge. So the thing is that it's not that I have a negative view. Obviously, drug trafficking I have a negative view of, but I'm just saying it's not that I have a negative view of Mexico. It's that it depends on what they do. I could see there being a strain, but I don't see it being enough of a strain to get rid of the USMCA. That's the thing, is that yes, it could put strains on it, and you may see tariff increases like we've seen with Canada and Mexico. But getting rid of the getting rid of the full zone, that is not something that I foresee for the future. If it happens, it'll blow me away. It'll be like a full shift in policy because we have to. The U.S. may be a really strong country. We may have great economics, right? Still number one economy in the world for GDP. China's catching fast, right? We may have all these things, but we still have to have partners. We still have to have people around us that are working with us. And Mexico is one of the greatest ones because of the less expensive labor. Although labor pool is increasing there, right? And they just increased minimum wage, and then people are going up in salaries across the board. But it's still a third of what you pay a worker here. So when you're looking at it that way, you have to say, okay, but we're still getting the labor needs that we have need of here in the U.S. for certain things like manufacturing, especially. And so I just don't foresee it going away. But if USMCA does go away, TN is based on USMCA, which means that it would likely go away as well.
Yeah. Even Michael, even if it's something changed, then it will be a transitional change, right? It's not going to go
That's right.
away. Yeah.
Yeah,
All
because
right.
that's not something the president can do either.
Yeah.
Because you're talking about the USMCA is congressional, right? So this is a law. Yes, it's a type of treaty which comes out of the executive branch, but it's not just a treaty anymore. It's actual law. So being that it's actual law means that there would have to be a congressional act in order to take it away.
That's right. Okay. Thank you, Michael. We have another question from Sankalp, and he has a situation. So he's currently on F1 STEM OPT, and he's a bit nervous about traveling to, I believe, home country India, and considering he's applying for H1B for the last time in 2026. So he's asking what would be the good time to travel and come back.
Anytime. So the thing is, as long as he's still doing what he needs to do for OPT, right? So it's optional practical training, and he is still satisfying the requirements for that. Applying for an H-1B isn't gonna harm him and his F-1 in any way because H-1B is a non-immigrant dual intent visa, so there's no permanent intent. So as long as he still has everything current and he still satisfies the requirements under OPT to keep it current, because any violation of the terms of a visa, for instance, you're an F1 and you get caught with a DUI, that's a violation of your term, right? Which means that technically your F1 at that moment should be canceled. So there are things that matter, but as long as he doesn't have anything like that and everything is up to date, applying for an H-1B won't have any issue. It won't affect his ability to travel under F1 at all.
All right. Okay. Arushi has a question saying that, hi, if the beneficiary's job role falls under multiple SOC codes available on DOL OFLC wage search website, how does the employer choose the SOC code? Given these SOC codes have different wage levels, would this SOC code play a role later in the immigration process for EB2 or EB1A filing?
So for EB1A, there's not really a SOC code
Yeah.
because EB1A is self-petition, right?
Mhm.
But EB2, if you're NIW, then it doesn't apply. It shouldn't apply either. But EB2 general, right, which is the non-national interest waiver through an employer for extraordinary, for exceptional ability, right? So the SOC code does matter, right? Because if you have different wage levels, really it's up to the employer which one they want to choose. A lot of employers will choose the one that some employers, if they're worried about money, then they'll choose the one that's the least pay, right? And when you're talking about level 3 and level 4, if you qualify. Many of them, the most important thing is what your actual job function is going to be.
Yeah.
And so what's the primary job function? If the primary job function is I'm going to be a mechanical engineer, then you're going to want to look for the one that fits primarily in that, use that SOC code, and then determine under the DOL which category you fall under, not just SOC, but also looking at the level. How much experience do you have? And because then that can determine the pay, right? Because now, you fall into level 3, but it's only $140,000 a year versus if you were something else related to that. I'm a let's say I don't even know, I wouldn't even give an example right now, but something higher level that's a higher pay, that when you fall into level three, but they got to pay you 180 to meet the standard of level
Yeah.
three, right? So
Right.
then that's really a question for the employer. And usually the employers have people that they work with in order to determine that.
Right. And also, Michael, just adding a few lines. When someone is planning to file for EB1A, so if they are benchmarking the high remuneration, then we can strategically understand that what would be the designation via SOC code.
Yep.
Usually, it always differs what's given in the SOC code and what's actually their designation is. So, moreover, their JD matters a lot that how it is getting synced up.
Right. That's right. Yeah, because that's really what you're looking at. I mean, a lot of people don't fall under high remuneration. I mean, you got to be in your specific area with your level of experience, which means under a certain level, right? Now you're looking at that level. Are you getting paid in the top 10%? Right. Basically, that's how I look at that standard. And so it becomes a mathematical equation, but it's still very subjective, right? It's like, well, somebody that falls in the 20 but works with mostly nonprofits, right? You just never know. It's really difficult to know how an officer is going to take that into consideration as compared to I was published in the Times and I was cited 50 times in the last year, right? It really there's more solid and less subjectivity when it comes to certain things, whereas I find high remuneration to be a lot more subjective.
Right. We have another question by Pragya, and she's currently very early in her career, and she just completed her master's in computer science, and she's exploring O1 visa. Her question is, given the profile is currently a little weak, what would be the steps to make the profile strong?
So just what I've said. So the idea is that you work with someone like Open Ventures and Open Atlas in order to be able to figure out what it is that you need to add to your baseline. Publishing, getting things taken, peer review, becoming a member in certain things, seeing if you can get a position of authority in your membership. Like I'm now the secretary of my, group that I'm a member of, that kind of stuff. But then really pushing it out to make sure. So a lot of people will just write things in order to get something published. You need to write stuff and make sure that you're publishing stuff that is actually usable, not just for you and whatever you're doing, but also for other people. And then really pushing that out, really working on making sure other people find it, that it's visible, and that it's being used, being cited, stuff like that, in order to make it a deeper. It is going to be harder. There's no doubt. Getting O1As are going to be harder. Getting EB1As are going to be harder. And that's where we've seen the RFEs. That's why we've seen so many,
Mm,
because there was a certain standard of application that was happening under the previous administration. And the new administration says that's not enough for us. And you're going to have to do better because you gave us a lot of stuff, but you didn't give us a lot of depth. So really focusing on that. So anyone who's on an F1 that is new and early in their career, more likely they should apply for H-1B. If they're in the US and they just finished their master's, they're not going to be subject to the $100,000 fee, so they don't have to
mm,
worry about that. Finding an employer who's
mm.
willing to bring them on under H-1B, it's a relatively inexpensive visa when you compare it to other visas. It's pretty good. If you get selected, it's great. It's better to do it when you're in your OPT, when you still have time to do it twice, so you get two bites at the apple at least. Being in CS, probably she could do a STEM because I think CS falls under the STEM programming. So maybe even a extension of her OPT to CPT or into the STEM extension, and taking a bite at that H-1B apple multiple times while you build it. I just think based on what we're seeing that a person that's new in their career that has less than, in my opinion, 5 years of experience, could be
Mhm.
less than that, it could be three, but you have to show that you have experience plus impact. So
Yes.
that's really when people should start applying for O1A. And until then, you should really be looking at other pathways that are allowing you to build that resume in order to have a qualifying and prepared. And also, you might find that the next administration is not as harsh on the standards. And so, by you
Mm,
doing an H-1B and being the next 3 years under H-1B, then you're applying under a new administration that doesn't have the same standards.
right. Yeah, and also in O1 is also like extraordinary ability achievements. So it needs to be very strategical when it comes to O1 and EB1A. So there are like 10 criterias, but we cannot like just keep on pushing all the 10. We need to choose strategically which are the
Yeah,
best, aligning with our niche or the professional, career that we have chosen. And then we have to pick up the best out of the
that's
platform
right.
that we have.
And then make it deep. And
Yeah.
then really focus on those to make them deep. So instead of being like, we're going to do
Yes.
6 of them, let's pick 4. And those 4 need to be really well done and like deep, right?
Yes.
And make sure that there's plenty of evidence that show that you've actually had a quantifiable impact on a national or international level. So that's really the key here, and that's what I'm trying to beat the drum of. It's not just about how much you give, it's about what you give and how deep it is, to show that this is why people are getting RFE'd. They want you to show that you've had a quantifiable national impact or international impact, and they need the evidence to prove that. So the other side is they could RFE people. So don't freak out if you get an RFE. That's not a death nail. NOID to me is much more like, that's like the end of the line to me. But the RFEs are not a death nail, right? Sometimes they're just trying to do case backlog management. And they're like, we have too many. We got to send out some RFEs in order for us to give us more time in order to process all of these. So,
Yes. Okay. Um, there's another question, Michael.
mhm.
Praveen is asking, he has a 13 years of experience in software. Any direction on how much it would be difficult for an experienced professional for visa? What can be done from experienced professional perspective?
It's the same thing. It sounds to me like he has a lot more to give because
Mm,
he's got 13 years of experience.
yeah.
So, but I know people in the law with 13 years of experience, is like, I wouldn't hire them, right? Because it's like, yeah, you've made your way through it all this time, but you haven't actually made an impact. And I don't see that if I brought you in and paid you what I would have to pay a person with 13 years of experience, that you're going to provide me the return on my investment. So the real question is not how many years necessarily, but it's about how much impact you've made. Can you prove that you've made an impact? So really, it's the same metric for people that are newer, right? It could be looking at it a different way. Person that's just finished has had no impact. They're saying, okay, I need to get some experience and I need to get some impact. Then you have the person that's got 13 years and they're like, I have all the experience, but I don't have any evidence or documented. I've never published anything, right? I've never been a speaker at an event or a conference. I've never had a paper that's been peer reviewed. I've never been a judge for, those kind of things. I've never won any awards. It's about seeking those, because, and that's one thing I focused on when I was early in my career, was getting awards, right? Why I didn't care about people saying that I was good at what I do. I already know I'm good. I did it because other people sometimes care about that. So now I have walls full of awards. Why? Because I focused on making sure that I got in front of the right people in order to be seen to get those awards. They didn't matter to me one hill of beans. I couldn't care less, but I knew other
Mm.
people would care. So when somebody walks into my office and sees walls of awards, they're like, wow, this guy knows what he's doing, right? And so then that's one hurdle that I don't have to overcome, to be like, are you the right person? Well, obviously this guy's got the experience and the knowledge and he's good at what he does. So now let's just talk about what's my situation and what's the price, right? So it's really about maybe shifting focus from head down approach, just working and getting your job done, to making sure that you're taking a little more time to consider who's watching you, where you can get your stuff pushed, what kind of information that you have in your head and in your mind that can be useful to other people, getting that published in the right publications, then getting that seen by people. So it really is a shift in the way that you look at your job. As professionals, we look at our job as, I go and I do everything that I can do and I work to the best of my ability and I learn and I grow and I make an impact. How do I see that impact? I get higher pay, right? I impact my team. My team does a better job because I'm contributing to the overall outcome. We look at it as our benefit is doing better and being better and moving up in the chain of command, or getting higher pay and our team being satisfied. Whereas that's maybe internal versus external. So you kind of have to start also looking at the external factor and say, how can I make myself visible in front of people externally that can also provide some external feedback, awards, and so on and so forth?
Yeah. And also, Praveen, the thing is that if you're exploring visa, then a lot of things needs to be evaluated before choosing a right visa.
That's right.
So, yeah, so it needs a lot of counseling and understanding that what's your profile, what's your intent in the future, and other questions, and then you should go for the definite visa. All right.
Yeah.
Michael, there is a follow-up question from Sankalp. I believe I missed out in the previous. So he's asking, do he needs to declare his wage when he is registering for H-1B early March 2026, or does that come later when he get picked? He is asking this because he's expecting a hike in his salary in somewhere in April.
Well, he's not really declaring that at all. It's the employer that has to declare that because it's the employer that they're looking at to see are you getting paid the right amount compared to Department of Labor. So it's not really about him declaring it. If he gets paid higher than most people in his field, then when the employer says this is what our offer is, and here's what the DL, let's see, here's our LCA, right? And so we didn't find anybody. Here's the level this person falls under. Here's the DOL, wage certification. Well, then his pay is dependent on what that is, right? So if they're going to pay him $20,000 more than what the DOL says they should pay for a person with that time and that experience and that knowledge and background and education, then that obviously satisfies the requirement. But in H-1B, there's no special benefit to being paid higher. And you're talking about higher wage earners. Higher wage earners really fall under the levels. So yeah, there's going to be the issue of are you paying this person more, but it still falls under the level, right? So they are weighing it towards higher wage earners, but it's really about the employer determining what that wage is and declaring that wage. So when the initial registration happens, the end of March, early April, that's when they have to do that stuff, right? So they're saying this is how much we're paying for this position. So we're applying for this person. This is the position. Here's the LCA that says there's nobody else to do it, so on and so forth. So that's really when the wage comes into factor, and it's whether or not it meets the higher wage earners inside the H-1B categories. It's really an employer thing. I guess that's the point, though.
Mm, yeah. There is a follow-up question again from Martin. Does USCIS care about what authorship position you are in, second author, third author, when submitting research articles as long as it is heavily cited?
That's a good question.
Yeah, Michael, I can like take up this question, please.
Yeah, yeah, go
So,
ahead.
yeah. So, basically, Martin, it does not matter whether you are a first, second, or third author in any kind of authorship article, but rather than keeping yourself as a second, third, or fourth author in consistent articles, it is a good idea to keep yourself rotating on first, second, third position rather than
Mm-hmm.
keeping only just fourth or fifth. So it does not matter. It matters that how much contribution of yours is in that particular authorship article. Basically, if we go in the terms of research-based principles, it says that author who is on first position has given more in-depth understanding, knowledge, and percentage on writing that article. Hence, but the judgment or criteria selection is not based on which position you are in. So that's why I usually let all the applicants know that rather than keeping yourself on a second or third or any later on that any of the positions, you should keep the blend. Like maybe if you are going to publish 6 articles, keep 2 articles on the first position, keep one on third, keep two on or keep 2 of them on the second position, like that way.
Mm-hmm. Agreed. That's exactly how I was going to respond to that because the government doesn't expect you to be the first author on everything, right? Usually we work in teams, and there are multiple people coming together in order to work. Some people author stuff and publish it without anybody else, and that's common. But if you work in a team and it's like kind of a team effort, then making sure, and then also because remembering that they're looking at depth, making sure that your contribution to that article is actually first position contribution, right? Not that you're just put as first position, but making sure that you're the one providing like it's tagged to you the majority of it so that you merit the first position authorship.
Yeah, exactly. Michael, we have another question saying that does EB2 NIW provide any help for EB1 profile building?
They're very different. So you have to show that. So NIW, the national interest portion makes it different than everything else because it can't just be anything. In EB1A, it can be anything. If you can show extraordinary ability, you can show it in anything, right? You don't have to show that it's of national interest. The NIW was specifically created because we do have dearth in certain things. Like half the people we have working in nuclear sciences here, the high levels are from Iran, right? So it's like, why would that happen? Well, because maybe Iran had a greater focus in training people in nuclear engineering, right? Nuclear fission and being physicists in that way. So it's really about is there a national interest? But you also have to show that you're of exceptional ability in whatever the national interest is, right? So that's the difference. So showing your exceptional ability in any area, in NIW, it has to be something of national interest. In EB1A, it doesn't, is just a step away from showing that your extraordinary ability in something, right? So yeah, it does help. And so having it as under an NIW does help because you've already taken the steps of proving certain criterias, which are very similar to the extraordinary ability criterias, right? So the difference is that for NIW, you have to show whatever it is that you're showing is in the national interest. So
Yeah, and a few of the artifacts can be used, but not all. But it needs to be
mhm.
strategized that you what you have filed in EB2 and IW and how you want to aspire in EB1A. EB1A is basically your own achievements, but in EB2 and IW you are saying that hey, I am a very good resource for the growth of United States. So the difference comes in between there. Okay, Michael, there is another question from Arushi, I believe the follow-up question. What does maintaining an F1 visa status mean? Does it allow an F1 student work as an approved C14 EAD from USCIS, or will it violate the F1 visa status?
So C14 is a category specifically under deferred action. Um, it depends on what your C14 is. I'm trying to think if there's any C14s that would violate F1. So C14 is deferred action, which means the government can take action against you, but is deferring to do so. Usually we find those under like DACA was one example, although their C33 is just kind of a separate category that was created specifically for DACA. U visas, prior to being approved for your full U visa under A19820. Then you get a C14 for deferred action. So I would have to know specifically what it is, but I can't think of any off the top of my head that a C14 deferred action work permit would violate an F1. And being in F1 status just means that you meet the criteria, right? So you have your I-20 and your civis, and that you're currently studying, I think it's at least 12 credit hours, and that you have the way to pay for it, or a sponsor is going to pay for it. Obviously, you're enrolled in a school. That's why you're into 12 credit hours, right? Um, and that it's not expired.
Sorry, Michael. I just wanted to say that humanitarian visa, it is like a U visa. So certain discretionary cases or humanitarian cases is like on C14.
That's right. Yeah. So U visa is the primary one for that. There's not really a whole lot of humanitarian visas, quintessential humanitarian visas. That's a victim visa.
Mm,
So it falls under some people call it humanitarian, but humanitarian is really when you're coming and you're here and you need to stay here because you have a loved one that's sick or something like that. Usually that's humanitarian. So U visa is a victim visa, and yes, it's C14. And no, it wouldn't violate because U visas are a non-immigrant visa as well. So it's one of the few. It's also a dual intent, but once you're approved. So C14 is prior to approval on your U visa. So it would not violate. So if the U visa is the one that we're talking about, it would not violate your F1. Although you don't really need, for travel purposes, you could keep it. Um, but otherwise, the U visa is a stay visa, a stay and work visa. So you wouldn't need OPT for that. So if you're working under your C14, you wouldn't have to have OPT. So you could technically have your F1 and travel under your F1 and have your U visa ongoing or your U visa application ongoing under C14 for work authorization. So,
okay, thanks, Michael. One last
mhm.
question from Disha. How to handle RFE for H1B for people who will be in day one CPT?
how to handle the RFE for someone who's applying for an H-1B that will be on first day CPT?
Yeah, that's the question.
I don't have an answer to that question. I don't. I would have to look at that. I'm not sure what the RFE would say on the H-1B. I don't know why CPT would have anything to do with it. Um, because it's very common to have CPT or OPT and bridge the gap until October 1 when applying for an H-1B. So I'm not sure. I guess it'd really be dependent on what the RFE is about. They're not going to RFE you because you're on day one CPT.
Disha,
I
if
mean,
you
that's
feel comfortable, you can unmute yourself and make us understand your situation.
All right. So basically, I've done one master's, and then
Mhm.
my H1B didn't get picked, and so I've started another master, like another doctorate program, where I'll be doing day one CPT. So just wanted to and my H1B will be applied for the second time now in the March on my initial master's. So wanted to know if there, because it just the word that's going around that people are getting RFEs for because they have started a second program in the US, and if they apply for H1B, they get RFEs. So wanted to know if how do we how what do we say, and what do we how do we handle that kind of RFEs?
it really depends on what the RFE says. I can't think of one reason. I haven't had that. So I'm not sure why people are getting RFE'd on that. Having a second program in the US is not something to cause an RFE. There are a lot of people that come here for their bachelor's or come for their master's and stay for their doctorate. So I don't know. I would have to see the language one of those RFEs. CPT, it just means that you can start working on day one of your new program, your academic program in your field of study. So I don't see how either one of those would trigger an RFE. And since I haven't seen one of those RFEs, I'd have to see what it is that they're asking for, because there's nothing that comes to my mind immediately that would say that you should. Like, I can't think of a reason an officer would RFE it, not based on what you're telling me, right? Um, there's no issue with you working if you're on the CPT. There's no issue with you doing multiple programs in the US continuously, and there's no issue with you applying for an H-1B while you're still doing your program. So I can't think of anything individually or as a mix that would cause a trigger of an RFE. So I'd have to see the RFE to know how to respond. That's a very specific situation in question.
All right. Yeah. Yeah, go ahead.
Yeah, thank you, Michael. A long time back, I did work on one of the CPT RFE with an
Mm-hmm,
attorney, and I know the documentation is quite heavy in nature because these kind of RFEs are bit rare in terms. So
mm-hmm,
there are lots of trigger point that might have came up. So the documentation on part of schooling or the curriculum that has been going up, or the school, how the intensity of the school is, so a lot of
mm-hmm,
documents needs to be like sent to the USCIS in terms of RFE to make sure that whatever curriculum has been enrolled, it is like viable and is following the structured principles that has been maintained. Maybe the questions would be around there. And yes,
mm-hmm.
definitely what you said is like the language of the RFE matters a lot in
Yeah,
RFEs and noise situation, that what they are asking and how they are compelling on the
yeah.
RPO.
Yeah, I could see that if they dig in and they say, well, your curriculum and your academic program is too heavy for you to be doing a full H-1B, then I could see how they could ask questions like that. But that just seems like that
Mm.
can't be often. I've never had that. I've done hundreds of H-1Bs. I've never had that happen. So I'm not sure if it's just another loophole they're using right now in order to RFE more people for H-1B. Um, but that would be crazy because that's really what it sounds like. Is they're saying, why would we give you an H-1B when you're supposed to be in school studying and your academic program isn't viable if you're working as an H-1B? That seems crazy to me, but maybe.
Yeah. All right. I think we
All
covered. Yeah. Yes, Disha.
all right. Thank you. I just had one more follow up question. Is it so? There's another word around also that it's risky to travel on day one CPT. So is it something like that?
Well, really, you're traveling on an F1.
Mm-hmm.
So it's not really the day one CPT. You're really traveling on your F1. I will say that there has been increasing uncertainty with travel with any visa right now. I've heard of people coming to the border in Mexico with their residency card and have been residents here for 20 years, and they're stopping them from coming in. So I, I'm not saying you can't travel. I'm just saying that you need to weigh the pros and cons because we've seen the craziest stuff over the last year. People getting their residencies taken away from them at the border, even though you can't legally do that, but yet they're doing it, right? And so I would just be careful at any point in time and make sure you have your ducks in a row if you're going to travel, and only travel if necessary. That's kind of what I tell my clients is if you need to do this, then fine, but only travel when necessary because they could. That's the whole thing about the consular doctrine, right? They could say we're not going to let you back in for any number of reasons, right? And so it's like you're really asking for readmittance to the United States. And so if you're being readmitted, they have the legal responsibility and authority to do a full review of your whole everything that you have to see if that officer then and there is willing to let you back in. It's not a guaranteed return. So just be
All right.
careful.
All right. Thank you so much.
Of course.
Anybody else have any questions? Or I might have missed because a lot of people individually messaged me. Please feel free to unmute yourself and ask any of your question if you have. Okay. Michael, thank you so much. And everybody, thank you so much. It was an incredibly amazing session, and we literally loved a lot and learned a lot in this session to understand how was 2025 immigration and how to strategize and structure ourselves for the coming visas we are going to apply. So, Michael, will be happy to be with you again sometime very soon in January. Thank you so much, everyone. See you again very soon.
Thank you, Swati. Thank you all. Bye bye.
Bye bye.